Good morning to the Washington Legal Foundation's web seminar program. My name is Glenn Lammy. I'm Chief Counsel of the Foundation's Legal Studies Division. We are coming to you this afternoon from our M.J. Murdoch Center for Free Enterprise. For those of you not familiar with the Foundation, I encourage you to take a look at our brand new 2014 annual report, which is now available on our website. Generally speaking, we are a free enterprise-oriented organization that's been around for almost 40 years, 38th year this year. We do, I think, three things very well in addition to filing amicus briefs in a wide range of issues and cases in the Supreme Court, lower federal courts, state courts as well, filing regulatory comments. We also release publications on a wide range of issues through our Legal Studies Division, and through our communications program, we put on programs such as this, media briefings. We have a blog as well, the WF Legal Pulse, and the subject we're talking about today, we've sort of covered all our bases in terms of our capabilities on that issue. We're very interested here at WLF in delving into threshold issues in civil litigation, the really basic kind of stuff that first-year law students learn in classes like civil procedure. Standing to sue, minimum pleading standards, and jurisdiction are among such vital procedural checks on frivolous litigation and also help to preserve precious judicial resources. For those reasons, WLF has participated in Supreme Court cases such as Ashcroft v. Iqbal, Clapper versus Amnesty International, and Goodyear Dunlop Tire versus Brown, and has advanced their implementation and application through our activities, such as our legal policy papers and programs such as this today. That type of post-decision education and awareness raising has been crucial with cases like Iqbal, which, after all, arose in a context outside of the civil litigation realm. One of our speakers today, Tom Dupree, wrote two very widely read publications that WLF put out about the case in 2009, and our other speaker, Jim Beck, has written extensively about Iqbal and its partner case, Bell Atlantic versus Twombly, at the Drug and Device Law blog. Since the Supreme Court issued its Daimler AG versus Bauman ruling on this January 14th of last year, WLF has worked to ensure that business litigants understand and appreciate its importance. This program is part of that effort, and we thank our panelists for their role that they are playing in doing that today. Leading off will be Tom Dupree, who's a partner at the Washington, D.C. office of the law firm Gibson, Dunn Crutcher. He's a member of the firm's litigation department and its appellate and constitutional law practice group. Tom served in the civil division at the U.S. Department of Justice from 2007 to 2009, ultimately becoming Principal Deputy Assistant Attorney General. He argued on behalf of Daimler AG in the U.S. Supreme Court in the Bauman case. Following him today will be James Beck, who is of counsel to the law firm Reed Smith LLP and its Philadelphia office. He handles complex personal injury and product liability litigation. Jim is a member of the Product Liability Advisory Council and is a past member of the American Law Institute. As I referenced earlier, he is the founder of and regular contributor to the award-winning Drug and Device Law blog, and he's also the co-author of a June 2014 WLF Legal Backgrounder, The Other Shoe Drops on General Jurisdiction, Making the Most of Supreme Court's Bauman and Goodyear rulings, which is available on our website. Tom, if you could get us started.
Well, thank you, Glenn, and good afternoon. Thanks to you and to Washington Legal Foundation for organizing this event. As you noted, the question of personal jurisdiction is an absolutely critical one for all business litigants, and the Supreme Court in the last few terms really has been focused on that issue. I think in many ways the justices have recognized the excesses of some in the plaintiff's bar and aggressive assertions of personal jurisdiction, and have acted really to rein in some of the more unbounded assertions that in many cases have been upheld by the lower courts. Today, of course, our topic is the Bauman versus Daimler case. This is a case that is certainly near and dear to my heart, and one that I think it's fair to say has had a very significant practical impact on business litigation in the United States in the year or so since the case was decided. In fact, about 3 months or so ago, I was actually accosted by a plaintiff's lawyer who accused me of having deprived him and his firm of a $10 million case. And so he was very angry with me. And after venting for a few minutes, he then asked if I knew any ways to circumvent the Bauman decision. And so I said, well, no, I can't really think of any workarounds. Have you tried pleading specific jurisdiction? Which, of course, set him off even more, and so that encounter ended. But there's no question that the Daimler case, the Bauman case, has had an immense impact. And I know Jim is going to cover some of the more specific applications and how it's played out in the later courts. But I thought I would set the stage a little bit for today's discussion by just speaking about the case, how it got to the Supreme Court, what was on the mind of the justices, of course, what was in the ruling, and then offer a few thoughts on at least the first year of lower court implementation. Now, the facts of the Bauman case are truly remarkable, and I would submit that if I were to ask this group, a group of lawyers, if you were even, frankly, to ask a group of thoughtful laypersons the following question, that you have a lawsuit that involves Argentinian plaintiffs, a German defendant, and it's based on conduct that occurred in Argentina in the 1970s, where should that lawsuit be heard? Now, if you were to ask a group that question, I bet many folks, perhaps most folks, would raise their hand and say, it's obvious, Argentina. And I bet many others might raise their hand and say, well, sure, but how about Germany? And both are perfectly reasonable answers. But as we know from the Bauman case, the plaintiff's lawyers in that case thought the correct answer was San Francisco. And a panel of the Ninth Circuit agreed. The case really did rise on somewhat extraordinary facts. It involved a little over 20 plaintiffs from Argentina who alleged that they or their relatives had been victims of war crimes that occurred in the 1970s during Argentina's so-called Dirty War. And they argued that Daimler, or more precisely a subsidiary of Daimler, its Argentinian subsidiary, Mercedes-Benz Argentina, had allegedly been complicit in what happened to the plaintiffs and their relatives. So they sued, but they claimed that the lawsuit should be heard, and they filed their lawsuit in federal district court in California. So Argentinian plaintiffs, German defendant, foreign conduct, they sued in California. And the basis for their theory was that Daimler had a wholly owned American subsidiary, Mercedes-Benz USA. And according to the plaintiffs' theory of jurisdiction, it was permissible to impute the jurisdictional contacts of Mercedes-Benz USA up through to its corporate parent, Daimler AG, a German corporation that doesn't do business in the United States. Well, the district court threw out the lawsuit. Case went up on appeal to the Ninth Circuit, and interestingly enough, an interesting footnote to this case is Daimler actually won originally in the Ninth Circuit. The Ninth Circuit said district court was right, no jurisdiction, and there was a vigorous dissent from Judge Reinhardt. And at that point, things got interesting because the plaintiff sought reconsideration. The panel granted reconsideration, scheduled the case for re-argument, but before the case could be re-argued, the panel went and withdrew its original ruling and in its place replaced it with a new decision authored by Judge Reinhardt, upholding jurisdiction. So at that point, we sought en banc rehearing from the Ninth Circuit, and although we did not get it, what we did get was a terrific dissent from the denial of en banc rehearing, authored by Judge O'Scanlan and joined by 8 of his colleagues, essentially saying, really more in sorrow than in anger, that once again the Ninth Circuit has blazed its own trail. Once again, we look to the United States Supreme Court to correct the error. And the Supreme Court, of course, took the invitation, giving rise to the decision that we were just talking about. So the case, as it reached the Supreme Court, really called upon the court to define the parameters of general personal jurisdiction. And if you go back, and for me at least, when I first got into this case, I really had to dust off the old Civ Pro casebook and really relive, for better or for worse, the days of first-year civil procedure, which was daunting, but had to do it. So I went back and looked, and if you look at the Supreme Court's jurisdictional rulings, there are several eras. The first, of course, is the Pennoyer versus Neff era, which really had a rigid territorial focus to the exercise of jurisdiction, where the Supreme Court essentially held that the jurisdiction of a state court was coterminous with the state borders. This is the classic instance of if we find you within our borders, we're subjecting you to jurisdiction. That was the regime that prevailed really from the 19th century up until about midway through the 20th century, when the court decided its infamous canonical, or I shouldn't say infamous, famous and canonical international shoe decision in 1945. That was the decision, of course, that gave rise to this notion of minimum contacts. And of course, that then spawned decades of litigation over, well, what exactly are minimum contacts? What does it mean? And what was interesting to me as I started preparing for the argument and writing the brief and really diving into this area of law was that as you review the Supreme Court's jurisdictional decisions, pretty much all of them, with a few exceptions, but pretty much all of them concerned specific jurisdiction. I had always thought, well, you have specific jurisdiction and you have general jurisdiction. Specific jurisdiction, of course, is jurisdiction that depends on facts or cause of action that arose or has a nexus to the jurisdiction. General jurisdiction, of course, means that you could sue a defendant on any theory, on any claim, even if that claim itself has no connection to the jurisdiction. So I always thought there are these two poles, but when you look at it, the Supreme Court sure had said a lot about specific jurisdiction and really not that much about general jurisdiction. There were a few cases. There was a case from the 1980s called Helicopteros. There was a case that predated that from the World War II era called Perkins. And then, of course, there was the recent decision, Goodyear. But other than that, the court's focus had really been on specific jurisdiction. And so I think the court took the Daimler case to clarify the parameters of general jurisdiction and perhaps to strengthen what it had said in Goodyear, where for the first time in many years, it really gave some bite to the limitations on general jurisdiction by strongly suggesting that a corporation could only be subject to general jurisdiction in some limited areas. But it was still, at least in the mind of some folks, still a bit hazy as to exactly where the boundaries lay. So for that reason, the court, when it granted our case, saw it as an opportunity to really talk about what it meant by general personal jurisdiction. Now, there were some interesting facets to the Ninth Circuit's decision that perhaps also caught the attention of the Supreme Court. One, of course, was this question of attributing the contacts of a subsidiary to the parent. Now, of course, call me naive, but I had always assumed that in the United States we respected the corporate form, that if a subsidiary engaged in tortious conduct, absent a veil-piercing situation or some other extraordinary circumstance, you couldn't attribute the sins of the subsidiary to the parent. And the same, one would think, should hold true in a jurisdictional context, that if a corporation, consistent with the law of all 50 states, structures its affairs so as to ensure that it has no contact with a particular state and that its subsidiary is the one that carries out business, then there would be no basis for essentially piercing the corporate veil in the jurisdictional context and hauling the parent into court on the basis of its subsidiary's business activities. Well, the Ninth Circuit, and what I think can fairly be characterized as a creative approach to the issue, essentially pierced the corporate veil. It came up with an unusual test where it basically said, well, we're going to hold that if the subsidiary is performing activities that are of importance to the parent, well, then it's fair to bring the parent into state court. Now, of course, there's always the counter-argument that, well, if the services the subsidiary was performing were not important, then why would they have the subsidiary doing them in the first place? So it really was a test that would be satisfied in pretty much every circumstance one could imagine. So on the basis of this notice theory, the Ninth Circuit essentially pierced the corporate veil and held that Daimler, the parent, was subject to general personal jurisdiction in California on the basis of its subsidiary, Mercedes-Benz USA's contacts in the jurisdiction. Now, when the case went up to the Supreme Court, it was very interesting. The argument was very vigorous, robust questioning for both sides, and the court was clearly bothered with the facts of the case and just the unseemliness of bringing in this foreign parent on the basis of its subsidiary's contacts. There were questions about the Ninth Circuit's approach to notice. There were questions about what it meant for a corporation to be at home in a jurisdiction and whether this at-home test was really the test for general personal jurisdiction. There's one very interesting moment in the argument. It's toward the end of my argument where Justice Sotomayor asked me from the bench, he said, well, Mr. Dupree, do you care on which ground we rule in your favor? Now, of course, that's a great question to get if you're arguing. So I was happy to get the question. And interestingly enough, the answer was yes, we actually do care. Justice Sotomayor's question, as I think became later apparent from her concurrence in the decision, is that she was wondering whether the case could be resolved on a narrower basis. That is to say, whether it would be possible simply to ignore the test for general personal jurisdiction and resolve this case on the basis that asserting jurisdiction over Daimler AG was simply unreasonable. Somewhat of a totality of the circumstances test. Foreign defendant, foreign plaintiffs, foreign conduct, no real nexus to the United States, unreasonable. In my view, that certainly would be a permissible way for the court to have decided the case. Certainly we briefed it and we offered it as an alternative ground for the court to rule in our favor. But the answer that I gave Justice Sotomayor is actually it does make a difference. And while we certainly wouldn't look askance on a victory on any route, we thought that the better way to resolve the case was on the ground that the court ultimately did, which was, of course, a much broader holding. The court ultimately concluded by a vote of 8-1, and the 1 was actually Justice Sotomayor's concurrence, not a dissent, but a concurrence. But the majority of the court held that the assertion of general personal jurisdiction over Daimler AG was not permissible under the Constitution. The court clarified the test for general personal jurisdiction by limiting the places where a corporation could be subject to general personal jurisdiction to 2. Its state of incorporation and the state in which it maintained its principal place of business. The court explained that this so-called continuous and systematic test that had been applied for many courts for decades, in fact, it was in all of our Civ Pro textbooks way back when, that if a corporation engaged in a systematic and continuous course of business in a state, it was subject to general jurisdiction there, that test was jettisoned. It is no longer the law of the United States. So in that respect, there's no question that Daimler effected a sea change in the law of general personal jurisdiction. If you were a national or international corporation that did business throughout all 50 states, the day before Daimler was decided, you potentially were subject to general jurisdiction in all 50 states, assuming you did business everywhere. The day after Daimler was decided, you were subject to general jurisdiction in 2. It's a big change. Forbes magazine said that this is an earth-shattering decision with very significant consequences, primarily for the plaintiff's bar, in that it really would potentially put an end to at least some of the more egregious abuses of forum shopping that we've seen. But more than that, I think the decision also really now places the focus in terms of jurisdictional litigation in the United States. It really puts the focus on specific jurisdiction. And this is something, in fact, that Justice Ginsburg, who wrote the majority opinion, talked about, in that she said, over time, specific jurisdiction has played a greater role in jurisdictional analyses in the United States. And certainly the Bauman decision furthers that. And the way that she framed it makes it seem as though specific jurisdiction really needs to be the threshold question in inquiry in these cases. Do you have specific jurisdiction? And you really only go to look to general jurisdiction in those cases where specific jurisdiction might be unavailable. In some senses, it's almost like a backstop. But there's no question that the consequence of the court's ruling in Bauman really tells plaintiffs' lawyers that, look, you better have specific jurisdiction, because if you don't, and unless you're suing the corporation in its place of incorporation or where it's got its main headquarters, you're out of luck. The court cannot entertain that case. So I think it has been, from that perspective, a very helpful decision. There was some talk soon after the decision came out as to what the court meant when it noted in passing that it wasn't forever going to say that these are the only 2 locations where you can get general jurisdiction. It noted the possibility of an extraordinary circumstance where you might be able to get general jurisdiction over a corporation in a state outside those 2 states. But thankfully, and I'm sure we'll hear a bit more about this in a few minutes, the lower courts haven't really taken that exception and run with it. I know that I had advised a lot of clients about the contours of Bauman after the decision came down, and that was one of the areas that a lot of us were focusing on. One could imagine lower courts basically taking that language and basically deeming every case an extraordinary case for one reason or another. But thankfully, we haven't really seen that play out in practice. By and large, there are some exceptions, but by and large, I think it's fair to say that the lower courts, for the most part, have been applying Daimler faithfully. They have been restricting exercise of general personal jurisdiction. I think the plaintiff's bar is beginning to recognize this, and they are now thinking that they really do need to focus their claims and their lawsuits on the basis of specific jurisdiction, which really is the way that I think it should be. I think it ensures fairness. I think it ensures adequate notice. And I think it goes a long way toward eliminating some of the more abusive excesses that we have seen in the last 20 to 30 years. So that is my overview. I will now turn the floor over to my colleague Jim, who's going to give us a sense of what the lower courts have been doing.
Thanks, Tom. Jim is going to be following a PowerPoint presentation, which you'll be able to see on your screen there. If for some reason you'd like to get a copy of it during the program, just email us at interactive@wlf.org, and I will send it to you.
Can we go to slide 4? I have no idea where we are because I can't see it. But I have 3 takeaways, basically from the last year of Bauman-related litigation. 1 is consent, which we'll get into. 2 is CAFA. And 3 is class actions. Now, the litigation implications of Bauman, as we discussed, are massive. And I'd like to thank Tom right off the bat for producing such a favorable result. I think it can truly be described as historic, and my presentation is basically on how we can make sure that that happens. We owe it to our clients and to use every tool that we have that Bauman has given us. And we have, as I mentioned, an exception for exceptional circumstances, which should be, and so far has been, very limited, because it's based on essentially a situation where the corporation was a war refugee, and the entire corporate structure had lit up and moved from the Philippines to get away from the Japanese to Ohio, and that was considered to be sufficiently extraordinary. And that's pretty much where we want it to stay. The most significant aspect of Bauman that we'll get into is the limitation on forum shoppings by the plaintiffs, particularly in mass tort litigation, but generally. It will also restrict, and has so far been restricting, the existence of nationwide class actions, which is another bane of corporate existence. And together with a prior case called, I guess, Kiobel, I don't know, you had to learn how to pronounce it. Kiobel, it has pretty much eliminated these alien tort claims and associated grounds, because Kiobel took out the federal statutes, and this took out any state law follow-on claims. So what happens is, this was not a close case. This was 8-1. And that's important, because as we go forward, that means we have a justice or two that we might lose and can still expand and keep the heart of what went on in Bauman. There are a couple of things still out there. One is the jurisdiction by agency. Now, in Bauman, the justices took enough shots at that, calling the test that had been accepted that leads invariably to jurisdiction. So there's this agency out there. It hasn't really gone very far beyond classical agency in the other cases. The Ninth Circuit sort of got cut off at the knees, even though the decision was not based on that ground. And the other one that he has is, I mentioned the word consent. There's this idea of consent, which is not really consent. What it is most corporations, in order to do business in the state, have to register to do business, and that includes appointing an agent for service of process. And plaintiffs have tried to call that consent and come up with a new basis entirely for federal jurisdiction. And we get into that. But basically, this is a due process decision. So you can't really escape it by going to state statutes. Because as long as you have something that is so, the court used the word grasping, the court used the word exorbitant, these theories of general jurisdiction to spread it widely across the country so anybody can sue anybody anywhere, regardless of the basis for it, it's going to face a due process standard that is about that. So if you even if you call it consent, you still have to face with due process, and that's what the courts have done. Bauman was also, at the beginning, he had an issue of the fact that personal jurisdiction is waivable. After the passage of a year, that's not really that much of an issue, because we tried to get the word out that this is something that needs to be raised by defendants right away. And right now I would say that waiver questions of general jurisdiction under Bauman are really now mostly an appellate issue for defendants that have lost the case, lost the issue before. Go on to slide 7, please. In the last year, I think we can say there are 6 things in general that Bauman has done. First, the at-home test has been accepted. even though the at-home language was a relatively recent grafting on to the prior general jurisdiction continuous to substantial standard. It was grafted on, I believe, in the Goodyear case. I don't think it existed before that. That has been followed. There has not been much quibbling in the lower courts about the at-home test. The courts have agreed that this test significantly restricts general jurisdiction. So that's another wing that's been consensus. There have been some attempts made to say that a domestic corporation should not have the same general jurisdiction restrictions that the alien, i.e. German corporation had in Bauman. This was actually the point of Justice Sotomayor's, it's called a concurrence, but for really all our purposes, it's essentially a dissent. But that has not been followed by pretty much any court at all. The consensus is that domestic companies and foreign companies have the same general jurisdiction standards. There has been no attempt to retreat on the issue of stream of commerce in general jurisdiction. That was decided in Goodyear, and plaintiffs attempted to get back to it every now and then. After Bauman, there's been no backsliding to speak of on that point. Finally, there's the question of the internet. There have been a lot of cases, and they go back to when the internet was a new thing and nobody knew how it was going to evolve. And there were scary standards out there about whether if your website anywhere in the world was interactive, that was going to create general jurisdiction anywhere in the world. And this was before every website became interactive, essentially. That's out the window now, because you now have two places in which you can obtain general jurisdiction, essentially. The principal place of business and the state of incorporation. And all this frightful internet language in some of these, particularly in the older cases, has gone by the boards, and I don't think we'll have to worry about internet activities establishing general jurisdiction anymore. That, I think, has been washed away with Bauman. And finally, the issue of waiver. I put one case on my slide. In the Second Circuit, the court ruled that under New York law, this question of that you had anybody doing business in New York automatically established general jurisdiction was so ingrained that the theory of avoiding jurisdiction that was established in Bauman was not available before Bauman, and therefore it was not waived by not raising it. I just bring that out there because if you've lost on one of these issues, this is a good appellate decision to have in your pocket if you're trying to have to deal with a waiver question. Next slide, please. Now, the greatest potential impact, Bauman, is on what we call judicial hellholes. This is where the courts are so biased in favor of the plaintiff's side, or perceived that way, that they attract plaintiffs, which we sometimes call litigation tourists on the defense side, from all over the country and all over the world to file suit in these jurisdictions against anybody. And that was basically allowed by what we learned in our civil pro textbooks when we were going to school, and that the standard was just simply continuous and substantial doing business in the state, period. And so the plaintiffs didn't have to worry about who they sued and where they sued. Bauman has the potential, and this potential is being realized over the last year, to stop much of this abuse. Because once a non-resident plaintiff files in a state other than their domicile, they lose the specific jurisdiction that was talked about entirely. And then they are left to their own devices with general jurisdiction, and Bauman cut them off at the knees. Said you can only file in the state of incorporation, the principal place of business. The exceptional circumstances have to be so exceptional, that's like a war. Consider how many defendants get sued in your average asbestos case. And many of these jurisdiction hellholes are driven by asbestos. They sue hundreds, literally hundreds of defendants without any regard to where these defendants are located. Now that's okay if they're suing in their state of domicile. They have specific jurisdiction, and you can check for minimum contacts. And if they contribute to an injury in the jurisdiction, there's a good chance there's going to be jurisdiction under the minimum contacts test. But if they sue in the litigation hellhole where they do not reside, then they're not going to be able to obtain personal jurisdiction over 95 out of 100 defendants that they've raised in an asbestos case. That is going to change the perception of the people bringing these lawsuits. Now, also the question becomes, unlike asbestos, in a lot of mass torts, there is a specific target company as part of the litigation. There are other defendants brought in, but there's one specific target company. And so the situs where you can bring those cases is now limited, and you cannot bring them in Illinois or Pennsylvania or California or one of these other places that are notorious unless the company happens to be at home here. If you don't do that, you're going to lose the target defendant. And that is also going to go and affect how the plaintiffs view these kind of cases. So you will still have litigation hellholes. They'll still exist. They'll still be just as biased as everybody thinks they are, but you're going to have it without litigation tourism, so they're going to be smaller, and conceivably there may end up being more of them. But they're going to definitely be smaller, and that's the guts of what Bauman is really all about. Next slide, please. What are the results? We've got a year of cases under our belts. First one is California. In California, they started, oh yes, this is definitely not going to meet the general jurisdiction standards of Bauman. But they turned around, and the California appellate court, acting essentially sua sponte, which means without briefing of the subject, decided to take and graft the continuous and substantial test that had previously been for general jurisdiction onto specific jurisdiction and expand specific jurisdiction so it was available to plaintiffs who did not live in the state. That sort of made a lot of people's jaw drop, but then it got better fast, because within a month or so, the California Supreme Court took that case, and it's pending right now. And so one way or another, we're going to get a resolution to that. And it's either going to be in California, or that is a case that will have the Supreme Court written all over it if California Supreme Court goes and allows a form of specific jurisdiction that essentially encapsulates and allows plaintiffs who are not in that jurisdiction to sue. And that's one of the, I think it's important to have an extra Supreme Court justice or two on your theory and in your opinion, because you might lose one once you start talking about specific jurisdiction. But the test is due process. And I think it doesn't matter what you call it or how you phrase it. If you're going to effectively say you can be sued anywhere by anyone, there are a lot of members of the Supreme Court that have a problem with that. And I don't care what you call it. And that's what happened in California. New York has been somewhat split. It had a very strong pre-Bauman doing business general jurisdiction test that goes back a long ways, back to Justice Cardozo in the New York Court of Appeals. But the more recent cases have followed Bauman on the personal jurisdiction points and have restricted doing business and have indicated that those prior cases are not good law anymore. Illinois has been pretty good. Chicago courts themselves in Lake County have actually applied Bauman in cases involving mass torts. And I don't know whether you consider Oklahoma to be a hellhole jurisdiction or not, but there was a good case out of a place called Pottawatomie County where the judge looked at one of these mass complaints and dismissed over several of these mass complaints and dismissed over 700 plaintiffs because they hadn't sued anybody they could get general jurisdiction over after Bauman. So we did very well there. Missouri, which means basically St. Louis for our purposes, has been very good in asbestos cases. There was, however, a virtually incomprehensible Missouri Circuit Court opinion on a medical device case that looks like, if I'm reading it right, applied a California style of effectively allowing non-residents to invoke specific jurisdiction. It's a very hard opinion to read. And finally, in the asbestos MDL in Philadelphia, Bauman was applied in a case out of the Virgin Islands where owning a refinery, sending your ships, and having an extensive presence in the jurisdiction did not provide for general jurisdiction where the plaintiffs weren't from there. And so where the plaintiffs weren't suing for instance. So that, so we also have good law in asbestos in a number of ways. And next slide, please. Now I'm going to go into what the plaintiffs have maybe be their last best chance after Bauman, and that is the general jurisdiction by consent. And that is basically the at-home test is the law, and your better arguments might be to try to just find some way you don't have to talk about the at-home test. And what they've said is that there's plenty of law prior to Bauman on both sides of this issue, and that is that could you simply by registering to do business in a state, which most states require, or appointing an agent for service of process, and in some cases it involves contractual consent clauses, although those are mostly specific jurisdiction. I have seen them raised in the general jurisdiction. Is that enough to confer general jurisdiction? Because if it is, then Bauman becomes illusory, because for the major corporation from Bauman is the biggest help, they're probably registered to do business in most, if not all, jurisdictions. And so that means that the same situation would apply. And that's where I emphasize that this Bauman is a constitutional ruling. I don't care what you call it. If the effect is to let anybody sue anybody over anything anywhere, then I think there's a due process problem with that. Most states have not accepted that argument. New York cases have, in every case where it has actually been at issue, have agreed that the New York doing business standard is constitutionally suspect after Bauman and have not applied it. There are a couple of instances in New York where there's dictum in cases that really didn't have to reach the issue that go the other way, and probably because it wasn't briefed that much. There's been only one case that has flat out adopted the concept of general jurisdiction arises automatically from registering to do business, and that was in the District of Delaware. If there's any state that really doesn't need Bauman to assert jurisdiction over a large corporation, it's probably Delaware, because most of them are incorporated there. But it was a patent case. And it's an instance of one of the things we have to worry about in this, in that corporations, when they're acting as plaintiffs, sometimes make arguments to save one case that is against the long-term interest of the corporate entity and of the industry as a whole, and they need to simply consider that and whether they want to do that. That happened in this Delaware case because it involved drug companies, and drug companies are one of the major industries that are impacted by forum shopping and mass torts. And the court held that there was law in Delaware that held that there was general jurisdiction arising from registering to do business, and that law applies, and therefore it was general jurisdiction. But now there's another Delaware case that's going to be published that goes the other way on the same facts, and is so even in Delaware, the law is split. And I'm going to have a blog post on this question coming up on Thursday, which will lay all of this out. But other than the Delaware case, I would say there are at least a dozen cases where this argument, or one version of the argument of being registered to do business, asserting general jurisdiction, has come up, and courts have almost all rejected it in the cases that we've seen. And some of these are of interest to law firms, because there's one case, the Nevada Supreme Court just recently held that being a registered lobbyist, a law firm being a registered lobbyist, does not subject that law firm to general jurisdiction in Nevada. And so the things that are particularly of interest to law firms as well. Next slide, please. Now we go on to the second takeaway point, and that is CAFA. That's the Class Action Fairness Act. We have seen, since CAFA put a 100 plaintiff standard for mass actions, we've seen a lot of blatantly misjoined plaintiffs from all over the country. Complaints that have like 99 plaintiffs in them, or 95, that area, filed in the same hellhole jurisdictions, intending to avoid CAFA. And unfortunately, the defendants in those cases have only had so far some pretty weak tools to use to oppose them. That has been, they've had fraudulent joinder, which has such a ridiculously low standard for what is considered to be a plausible claim that's almost dangerous to use, because you end up creating law out there that says maybe the state would do this. And then you have fraudulent misjoinder, which has to do with lumping all the plaintiffs together. And that has been I would say it's a minority position even to adopt that rule. So those have been what you've had to use to fight this. You now have Bauman jurisdiction to go and prevent the use of these kind of complaints to avoid CAFA. Because they always put in a couple of non-diverse plaintiffs somewhere against at least the target defendant. But those non-diverse plaintiffs aren't suing in their domicile. So they have to go on the basis of specific jurisdiction which doesn't exist, and they don't have general jurisdiction if they're suing in a place where the target company is not available, is not doing business. So Bauman provides the way out, and it has worked. Next slide, please. The key is that with personal jurisdiction, when that gets into federal court, that's the first issue these courts decide before they decide any issue having to do with remand. There's a Supreme Court case, I've cited it on the slide that deals with that. So what happens is first you apply Bauman to one of the 99 plaintiff complaints. There's going to be a few plaintiffs, well, one or two, who are in the jurisdiction, and they can assert specific jurisdictions, they put them aside. Everybody else essentially gets dismissed. And so in a 99 plaintiff complaint, you probably lose 96 of them on the basis that Bauman does not provide any basis for jurisdiction. If you cannot assert a claim against any of the defendants you've sued, you don't have a claim and you're out of court. You get a dismissal without prejudice. It also results in the dismissal of the non-diverse plaintiffs from the defendants, because again, those plaintiffs are not the ones bringing suit. So they get dismissed, and what's left, whatever it is diverse and therefore stays in federal court. This has happened at least twice in decisions from Texas, which I've cited in my presentation. And this is one of the things that I speculated might well happen in the Washington Legal Foundation backgrounder that I did on Bauman last year. And so far it has worked twice in Texas, and the Oklahoma case that I described out of Pottawatomie County was effectively doing the same thing, but only in state court, and didn't have to reach the remand questions because that was the next step taken in the case afterwards. Next slide, please. There's a question then about how CAFA may evolve, and we've been hearing about imputation. You're talking about imputation of jurisdiction from one to another. Well, can you impute on the plaintiff side? Because what's the next question that's going to come up, and I have not seen any cases on it, are the plaintiffs that assert specific jurisdiction in these 99 plaintiff complaints, can the other plaintiffs piggyback a claim that they would not normally have of specific jurisdiction on the basis of one or two misjoined plaintiffs that are in the complaint? And this runs you into all of the exact same issues that you have with the issue of fraudulent misjoinder. As a doctrine, that doctrine has not succeeded in very many jurisdictions because it's swimming upstream. It's swimming upstream against the general disinclination of federal courts to go and bring cases into federal court on diversity jurisdiction. But when you put it into the due process context after Bauman, you no longer have that judicial thumb on the scale. And so I think the imputation is going to be a harder row for the plaintiffs to hoe, and the fraudulent misjoinder problems the courts are having, once you get into the question of due process and personal jurisdiction, aren't going to end up being as daunting as they have been for defendants elsewhere. And I haven't seen any cases on that yet. So, but it moves this whole issue of fraudulent joinder to a more favorable playing field. And so it all comes down to, when are you at home? And next slide, please. Now I'm going to talk about another thing that was in the WLF backgrounder I did last year, and that's Bauman and national class actions. Over the last year, Bauman has been applied in the class action context. There's not a lot of cases yet. You can probably go and run a search for Bauman and then class actions, and you come up with maybe 15 cases and read them all in about an hour. But the key for the purposes of nationwide class action, which is where I think Bauman will have the most effect, is the Rules Enabling Act. Because Rule 23 cannot, under the rules, none of the rules, but Rule 23 in particular, the class action rule, cannot change substantive law. And the substantive law after Bauman is there's no general jurisdiction unless the plaintiff and the defendant is at home. And so what this runs into is the class actions, national class actions, brought by one or two plaintiffs that might have specific jurisdiction or brought in the defendant's home state where there is general jurisdiction. The class action, the absent class members cannot create personal jurisdiction under Rule 23. That's the argument. And so they either have to file these nationwide class actions in the defendant's home state, where they can fight over specific jurisdiction, or they're not going to be able to file them at all because the creation of personal jurisdiction where it would not otherwise exist through the use of a nationwide class action should be a violation of the Rules Enabling Act because it is drastically changing the substantive law in that area. So the cases that are out there have not had to yet phrase it in the context of the Rules Enabling Act, but they have thrown out nationwide and even worldwide class actions as invalid under Bauman because of lack of personal jurisdiction, and the plaintiffs have not fought them that hard so far, so we don't have a lot of definitive rulings, but the cases that are out there are all favorable on the class action point. So the plaintiffs then are faced with a dilemma. If they're going to bring a nationwide class action, they're going to have to probably use a federal statute where they can try at least for federal aggregation of jurisdictional context on the idea of nationwide service of process and the fact that under federal statutes you're not limited necessarily by the state's territoriality. But that conflicts with the fact that normally, for a lot of other reasons, they like to be in state court. So they're going to have to make a choice on these issues to whether they want to bring a nationwide class action or whether they want to stay in state court. And that's another way that this is going to impact on the plaintiffs more in these cases. Finally, next slide, please. And one of the other things was sort of, it was at the end of the WLF thing I wrote. Bauman restricts politically motivated litigation. Bauman itself was politically motivated litigation. It involved claims of terrorism, suppression, and all kinds of nastiness that went on in Argentina. Well, we have had the similar kinds of litigation brought in the United States. The one that's the paradigmatic one for this purposes is climate change litigation. It's usually an instance where some village in Alaska or someplace like that sues a bunch of power companies who are doing business primarily in the Midwest or something like that. You're not going to be able to do that anymore after Bauman because, again, you're not going to be able to hail somebody from way outside jurisdiction into an unfriendly court and be able to assert general jurisdiction over them. And there's no way that these plaintiffs suing in their own place are going to be able to assert specific jurisdiction over lots of companies in different places. It's just not going to work very well. So the other one, this has come up in terrorism cases, and I've got them on the slide. D.C. courts have cited Bauman twice to say that you cannot sue the Palestinian Authority in the United States over overseas terrorist act. There's just no jurisdiction over them because they are not at home here or anywhere in the United States. And this is one where we've also seen a dissenting opinion out of or dissenting view out of New York, where this is the one situation where I have seen an entire class of cases denominated exceptional cases under the Bauman exception, and that has been with cases involving international terrorism. And so it's different enough that I'm not terribly worried about it, but this is a situation where you have to worry about the idea of just blanket saying an entire section, entire set of cases, entire subject matter is somehow automatically exceptional. That is something that would be very dangerous to have under Bauman for all defendants. And so we have to watch, even though we might really like the outcome in a particular case, whether it's going to set a doctrinal precedent that is adverse to us. Next slide, please. Finally, industry-wide liability. Remember market share liability? That was a big thing back in the 80s. Remember industry-wide public nuisance? That was a big thing back in the 90s and early 2000s. Well, there are not many cases anymore, but to the effect whenever the plaintiff is not suing in the home state on one of these theories, or is moved since the injury, Bauman is going to limit the ability to obtain jurisdiction over this mass of defendants that you have to sue in order to bring these kind of industry-wide cases. And particularly in the case of market share liability, that's right there as a substantive element of the case, that you have to go and sue a substantial portion of the industry. That's like 75% or something. You can't do that because Bauman doesn't let you get jurisdiction. That's effectively saying that cause of action no longer exists. And that's another thing out there. I mean, we don't see that many market share cases out there. And that's particularly an issue where you have national market share cases where the defendants don't even do business at all in the state and still have their market share counted. That might even be an interesting segue into specific jurisdiction issues out there now. And that's pretty much my presentation. It's a brave new world out there, folks. You got to go and use the tools that you've been given. So you also check out my Thursday post on jurisdiction by consent, and the existing posts they have out there on CAFA and Hellhole jurisdiction under Bauman. And I thank you very much, and I thank the WLF for letting me speak.
Thanks, Jim. Tom, wanted to see if you had any thoughts based on what Jim has been talking about.
Well, my first thought is that it's heartening. It's heartening. A lot of times I can think of a number of examples where the United States Supreme Court has articulated a legal standard that may be followed faithfully in some jurisdictions and perhaps not as faithfully in other jurisdictions.
Can we say preemption?
Well, there are a number. There are a number. And I will not identify the jurisdictions. But nonetheless, that hasn't happened here. And I think that is heartening. I think the lower courts have gotten the message. I think that the plaintiff's bar has gotten the message. And frankly, it's not in their interest to roll the dice and hope that some court will entertain their lawsuit, because for all the plaintiffs know, they could wind up thrashing around jurisdictional issues for a year or two, then get dismissed, only to find out that the statute of limitations has run. So it's a risky endeavor for the plaintiffs, I think, now to hope that they could persuade a lower court to somehow circumvent Bauman. But they're looking. That's what they asked me. I said, I don't know any way to do it.
Well, that's where this whole idea of jurisdiction by consent, which most people hadn't even heard of anymore, because it's sort of something that come up. It was a lot in the Pennoyer era when that was the only way to get them into another state's court. That has all of a sudden raised its head again as an alternative, and they don't want to talk about at home. They're not going to get anywhere on at home, so they try to find something else, and that's what I think they're looking at. And I've seen that come up in my home state of Pennsylvania, my home city of Philadelphia, for one.
Again, if you have any questions, interactive at WLF.org. I'd be happy to forward them on to the speakers. I wanted to read you a quote from another legal backgrounder that we did on this subject in April of last year. DePaul professor Mark Moeller, who teaches Civ Pro and other subjects, he sort of sounded a note of caution about Bauman. He said, if there is any lesson to be learned from 70-odd years of personal jurisdiction jurisprudence, it is that the consensus on the court in this area has not proven durable. Do you have any? Do you share that concern, or do you think that this is going to be durable going forward?
Well, Professor Moeller is a wise man. I may have a slightly different view than he does here. For one thing, as Jim noted during his presentation, this was not a 5-4 decision. We all know and love these balance of opinion, 5-4, Kennedy and the majority sort of opinions, but this was not one of them. This was either 8-1 or even 9-0 if you deem Justice Sotomayor's concurrence to be concurrence or dissent. But nonetheless, there is a large majority here supporting the principles in Bauman. Obviously, it reaffirmed to a large extent what the court had said in the prior term in Goodyear. Now, of course, we all know that the composition of the court can shift, and obviously it will shift over the decades ahead. But certainly from the early returns, from the fact that you essentially have a supermajority of the court endorsing this jurisdictional theory, I think we're good for the long term.
I think so too. This wasn't an Alito opinion. This was Ginsburg who wrote this opinion, who is not ordinarily a friend of defendants on a lot of issues. This is not a liberal conservative split. This is a situation where jurisdiction had gotten out of control, and practically everybody on the court wanted to rein it in. And I agree. I think that is here to stay. And the California case that's out there pending may be where that gets shown one way or the other.
How much of an influence do you think the makeup of the court is going to have in those kind of state cases? Is it going to have less impact than it's had in the federal cases, it seems, or the state justices going to go on their own way, you think, on these issues?
It's too early to tell because we haven't seen very many appellate decisions at all. The one appellate decision was from the California Superior Court, and it was way off the reservation. So that would be at least one data point that would suggest that the state courts are still going to try to squeeze out of it. But I think general jurisdiction, I don't think they're going to be able to go there. I mean, they're going to play their games with specific jurisdiction where we still don't know about things such as stream of commerce or issues like that. I think that's where the ball game's going to be, and that's good for any defendant that's stuck in a hellhole jurisdiction.
How do you think this is going to affect business planning, citing, those sort of things going forward? That's obviously been the litigation and what kind of jurisdictions you want to put yourself into has been an issue in the past. How does this change some of those decisions by businesses?
It's a great question, and one thing that really struck me was in the wake of Bauman, I fielded, as I'm sure many of us fielded, many inquiries from litigators and folks about, well, what about this hypothetical? Or if we did this, could we be sued here? And I've got this case and that sort of thing. And, you know, that I expected. I mean, that always happens after a big ticket Supreme Court decision. And I could answer those questions. One thing I didn't anticipate, but that I think foreshadows your question, is I've also gotten a lot of inquiries from my transactional colleagues, corporate lawyers who are looking at these jurisdictional rules and trying to figure out how to structure a deal or how to structure a transaction. And I think that's one thing that a lot of times people can lose sight of, is that these jurisdictional rules don't just have an impact on actual lawsuits that are filed and motions to dismiss and that sort of thing, but they also have a very significant impact on just business in general. I think that Bauman has given businesses a terrific tool for structuring their conduct so as to minimize the risk of liability, or at least the risk of being hailed into a foreign jurisdiction to defend your conduct that has no relation to that jurisdiction. I think it is a very, very positive decision in that it provides notice. That, to me at least, was one of the real vices of the prior system, is that you never could predict where lightning might strike, what crazy theory a creative plaintiff's lawyer might come up with to pull you into court on the other side of the country. And now corporations have notice. They have noticed that they can be sued in the two home jurisdictions. They also have noticed that they can be sued based on conduct that occurs in a particular jurisdiction. And those are fair rules of the game. And so I think that the ruling in Bauman has impact not just on the litigation side, but frankly across a wide variety of business activities, transactional deals, corporate acquisitions, very wide impact.
I agree somewhat. I think it will have a significant impact in companies from overseas that are coming into the United States for the first time and are trying to go and structure their way in. We've had jurisdictional issues before, and there's still lots and lots of companies that elect to go and establish their headquarters in a place like New Jersey, which is not terribly friendly on the state court system to defendants. So there are a lot of other things in play, and those other things in play I don't think are going to have a strong effect on where things get cited, because there are other things going on in business than being sued. Most businesses seem to operate going forward without thinking they're ever going to be sued, frankly. And so you would think that a lot of businesses wouldn't want to incorporate in California, but they do. So I don't think that you're going to have that much of an impact on existing businesses and where they're going to try to change things in order to avoid being sued. They may change things for other reasons. There's a lot of tax reasons you want to go and decide to be here, there, or somewhere else, and that I think ultimately has a greater, because that's certainty. You know you're going to be taxed, whereas you don't know you're going to be sued, and most people don't think that way. So I think that for someone coming in from overseas and starting a U.S. subsidiary, they're going to take that into effect. But I don't think it's going to be as much effect on existing businesses going forward.
In terms of your communications with your clients, how much awareness is there out there in the general counsel's offices about this decision and the benefits that it can have? Have you been surprised by the lack of it, or surprised by how much there is? There's not been nearly as much written about this case, I think, than other decisions like this. Something that we're trying to work on changing, but what's the impressions that you've seen out there, and also among fellow defense attorneys as well?
Yeah, my sense is people are very much aware of it. I mean, particularly those of us in the trenches who are litigating these things on a day-to-day basis, very, very aware of it. That said, I do think that people can use it even more aggressively. I think that there is a lot more that we, and I say we, I mean the defense bar collectively, can do with Bauman in challenging personal jurisdiction. So I've certainly seen it invoked, typically successfully in a wide variety of cases, but I also know of some cases where on first blush people might think, well, do we really have a Bauman argument here? And then when you start really looking at it and thinking aggressively and creatively, at least my answer often is, yes, we do, and in fact we have been successful. So my reaction is people know about it, but we can do even more with it because it is a great, great decision.
As Jim pointed out, if you don't raise it initially, you waive it. So certainly I would think
that is a problem. That requires an amount of in-house knowledge to go and make sure it gets raised in the first instance. And I have not seen a lot of in-house knowledge. Most of it is the drive is coming from the defense bar, the professional defense bar. I have been doing everything I can to get Bauman out there on my blog and to make people think about it, because I think Bauman is a great hammer. When you get a great hammer, everything looks like a nail.
Mark, did you have a question? Mark Chenoweth, our General Counsel.
I did, Jim. You were talking about the I think a potential conflict between the good trend that's happening with Bauman and the trend toward increasing diversity jurisdiction in federal courts. And it sounded like you think that if the diversity jurisdiction broadens, then that might be bad for Bauman. And I was wondering if you could say more about that.
Well, I wasn't diversity jurisdiction. It was federal question jurisdiction I was talking about, and that plaintiffs, particularly in class action litigation, want to find some way around Bauman, and one way to do that is to use a federal statute like RICO that allows for nationwide aggregation of conduct or service of process, as a way to avoid having to go and limit yourself to the boundaries of the state. I think, and the plaintiffs then are put to a they have to decide one way or another. They're put to an election. They have to decide whether they want to go and increase the size of their substantive claim and make their class actions more fearsome, and this, if they ever get it, to make it induced to settle, or whether they want to be in the forms that make them more likely to win, which is a lot of times in their favored state courts. And I think that Bauman goes and puts them to this choice. And I'm not sure which way they're going to go. Ultimately, I think most of them are going to go to a way they would think they're most likely to win. So I think they're going to go and abandon the nationwide class actions and do whatever they can to stay in state court. But it was not about I don't think diversity jurisdiction. I think Bauman helps diversity jurisdiction because it allows you to get rid of non-forum, non-resident, and non-diverse plaintiffs.
Well, let me ask a slightly different question, which is, there had been a movement before the Bauman decision was handed down to expand diversity jurisdiction with the thought, I think, that if you could expand diversity jurisdiction, defendants could get more cases into federal court and could avoid some of these hellhole jurisdictions.
Just general CAFA-style minimal diversity?
Right. Mm-hmm. And so my question would be, do you think that effort still makes sense in a post-Bauman world, or has Bauman gone so far to take care of, and Tom, I would address this to you as well, has Bauman gone so far to take care of the judicial hellholes problem that the effort to expand diversity jurisdiction maybe isn't, the game isn't worth the candle anymore?
I hadn't thought about that much, but in terms of legislation, I think it takes some of the sting out of it. It goes from being like a level 1 want on a lot of corporate wish lists to like a level 3, because it will not solve the hellhole jurisdiction problem. It won't solve it, but it will shrink it, and it will take some of the pressure off. So I think that in terms of the legislation, it does go and it decrease the perceived need for it to some extent, because the size of the problems has become smaller.
And I think there's still a need for the legislation. You know, maybe the need isn't as acute as it was in a pre-Bauman world, but I still think there's a need for it. I mean, look, these jurisdictional abuses are going to continue as long as there are plaintiffs and defendants. I suspect there are always going to be plaintiffs who really try to bring people into courts where they don't belong. And so any reform in the direction of fairness, notice, transparency, all of those are good reforms. And so the proposals I've seen, at least, I think still make sense, even in a post-Bauman world.
Gentlemen, thanks so much for joining us today. I hope everyone enjoyed the program. If you joined us late, or if you have any colleagues that may want to watch this, we will have it on our website as an archived file later in the day today. And if you have any further questions for the speakers, please feel free to contact them. If you have any questions for us with regards to our work in this area, please send us an email, and we'd be happy to talk to you further about it. Tom, Jim, thanks very much.
Thank you.